Think of the word relationship. Relationships are central to our daily lives. When a relationship is expected to last, people may form contracts, associations, partnerships, marriages. And when these relationships end, there's a lot involved in splitting up. Separating at the end of a relationship can be a long, exhausting and painful process involving emotional conflicts and legal disputes. Taking those conflicts and disputes into a judicial process is like declaring war, where the objective of each of the parties is total victory. Take the classic example of a divorce, which traditionally involves, on the one hand, an emotionally distressed husband and a lawyer armed to protect his client, and, on the other hand, an emotionally distressed wife and a lawyer equally armed to protect her client. In the center of this conflict, a fight about the fruits of their relationship, a home, investments, superannuation, and the most precious treasure, the children. And to complete this scenario, a judge who, despite the best of preparation, does not know the people involved, nor the unique needs of each family. The judge is given the power of deciding what will happen to everyone and everything in dispute. Too often, the result is that everyone loses. Children grow up in the middle of battles in the courts. Parents spend their savings on professional fees and costs. And the family often ends up needing psychological counselling to overcome the trauma of a contentious divorce. The moral of the story is that courts may not be the best place for many relationship disputes. But there is an alternative way, a method for resolving issues associated with separation and divorce without recourse to the courts: collaborative law. It is a method which recognizes that the end of a relationship is a human experience that is best addressed by a humanistic process for resolving conflicts. Disagreements between the separating parties are resolved by an interdisciplinary team in a collaborative approach. In a collaborative divorce, everyone works together constructively, face-to-face: husband, wife, collaborative lawyers, and, if necessary, mental health professionals, the children's advocate, financial advisors. All work together in a structured process, with the goal being consensus for the benefit of the family. Parties and lawyers sign an agreement not to take legal action, but to work as a team using constructive dialogue to build solutions and reach agreements. It's a win-win situation. The process is based on both parties' interests. It places value on human relationships, and it unclutters courts. Collaborative law was born in the United States in 1990 from the inspiration of a lawyer tired of working in a stressful mode and fed up with the destructive battles involved in divorce-related conflicts. Today, there are highly trained lawyers, mental health and financial specialists working collaboratively in disputes in the fields of family, civil and commercial law. There are more than 22,000 collaborative professionals worldwide and a strong presence in Queensland. Whether you are a potential client or professional, you are invited to consider collaborative law. Want to learn more? Visit Queensland Association of Collaborative Practitioners at qacp.org.au.